This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why creative pleading will never avoid the sloth of an insured or its lawyer to file suit timely, and why suing for unfair competition and an injunction to avoid the effect of a private limitation of action provision was dismissed by the California Courts of Appeal. Katherine Rosenberg-Wohl had a homeowners policy with State Farm, and it provided coverage on her home in San Francisco. The policy had a limitation provision that requires lawsuits to be started within 1 year after the date of loss or damage. In Katherine Rosenberg-Wohl v. State Farm, a July 11, 2023 decision of the California Court of Appeal, she sought indemnity to remedy a defect in the house. State Farm refused to pay because there was no insurable event and because the suit was filed more than a year after the alleged loss. In late 2018 or early 2019, plaintiff noticed that on 2 occasions an elderly neighbor stumbled and fell as she descended plaintiff's outside staircase, and learned that the pitch of the stairs had changed and that to make the stairs safe, a new staircase needed to be created. In late April of 2019, plaintiff authorized the work and contacted State Farm on August 9, where she submitted a claim for the money she had spent. State Farm denied the claim based on the investigation findings and concluded there was no evidence of a covered cause for accidental direct physical damage to the property. The denial also stated that the policy does not provide coverage for preventative nor safety measures to the property, with maintenance which should be and is the responsibility of the property owner to properly maintain the property to keep it safe. Plaintiff submitted a claim to State Farm for her construction expenses, which by then were approximately $52,600, with another $16,800 in anticipated expenses for additional work. By letter dated August 26, plaintiff alleged without any investigation, State Farm denied the claim. The letter also specifically referenced the suit limitation period as a policy defense. Plaintiff filed 2 lawsuits against State Farm in San Francisco Superior Court. One alleged 2 causes of action for breach of the policy and for bad faith. That lawsuit was removed to federal court and was resolved against plaintiff on a motion to dismiss based on the 1-year limitation provision. It is currently on appeal in the Ninth Circuit. The second suit before the Superior Court purported to allege a claim for violation of California's unfair competition law. The case was also resolved against plaintiff, also based on the limitation provision, and when the trial court sustained a demurrer to the second amended complaint without leave to amend, plaintiff appealed. On October 22, 2020, some 18 months after she had replaced the staircase, 14 months after State Farm had denied her claim the first time, and nearly 6 months after the 1-year limitation period of the policy had expired, plaintiff filed 2 lawsuits in San Francisco County Court. On April 20, 2021, Judge Masulo sustained the demurrer with leave to amend to add additional facts supporting waiver. On May 21, plaintiff filed a second amended complaint, adding, apparently without leave of court, a claim for false advertising. The SAC then states, again in capitalized boldface, that this is not a lawsuit for damages for breach of contract. Rather, it is a challenge to how State Farm does business. State Farm filed a demur and a motion to strike the second amended complaint. On July 29, Judge Masulo entered her order sustaining the demur without leave to amend, a comprehensive order indeed, 8 pages of thoughtful analysis, according to the Court of Appeal. She held that the court is persuaded that plaintiffs' claims are nonetheless on the policy because they are grounded upon State Farm's failure to pay policy benefits. She concluded that all of the alleged acts which form the basis of plaintiffs' claims occurred during the claim handling process. Finally, Judge Masulo held that State Farm had not waived the limitation provision. The 1-year limitation provision in the State Farm policy is there because it was required by statute, California Insurance Code Section 2071. The 1-year limitation provision has long been held valid as mandated by statute, and in fact, since at least the year 1900. The 1-year policy limitation provision was found to apply because State Farm asserted that the legislature had expressly endorsed the provision under Insurance Code Section 2071 and argued that because the allegations in this case all concern how it handled plaintiff's claim, the suit is subject to the policy limitation period under the applicable law. In sum, the crux of plaintiff's claim is grounded upon a failure to pay policy benefits. An insured cannot plead around the 1-year limitation provision by labeling her cause of action something different than breach of contract, which of course includes claims for bad faith. Conduct by the insurer after the limitation period has run cannot, as a matter of law, amount to a waiver or estoppel. The policy requires any waiver to be in writing. Plaintiff does not allege, nor did State Farm do, or waive anything in writing. Therefore, the judgment was affirmed by the Court of Appeal, and State Farm was allowed to recover its costs on appeal. In my opinion, the Court of Appeals spent many pages resolving this fairly simple dispute. The plaintiff sued to collect benefits she believed were owed under a policy of insurance, only to find that the suit was filed too late. To avoid that problem, she amended the suit to allege unfair business practices and sought an injunction, all of which were seen to be an alternative way to obtain policy benefits, and failed again. For more than 120 years, since the California Supreme Court decided a case called White v. Home Mutual in 1900, the private limitation of action provision required by statute and no amount of creative pleading can avoid its effect. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. It's also available free as a video on rumble.com and youtube.com, where you can subscribe. If you subscribe, you'll receive notice of the blog postings, usually 5 or 6 a week, and you can also receive additional access to the more than 4,550 blog posts. If you found this video to be useful to your friends and colleagues, please tell them so that they can also subscribe to the blog and the videos. And if you wish further detail on insurance law, insurance fraud, and insurance claims, you might consider subscribing to Excellence in Claims Handling at locals.com or to my Substack publications for a very small fee. Thank you for your attention.